My name is Katie Palms, and on behalf of the Board of Student Advisors and Dean Kagan, I would like to welcome you all to the final round of the Ames Moot Court Competition. The case before the court tonight, Hubbard versus Andrews, was written by Meryl Kessler and Julie Barton. The case presents two questions. The first, regarding the extent to which the First Amendment protects extracurricular, online speech by students at a public university. And the second, regarding the circumstances under which the 14th Amendment requires a public university to give an employee a name-clearing hearing. Petitioners Sophie Hubbard, Jeanine Lopez, and Hector Betancourt, undergraduate and graduate students at Ames University, are represented by the Honorable Iftikhar Muhammad Chaudhry team. Ishan Baba, Jonathan Cooper, Alexandra Davies, Christina Kraus, Logan Steiner, and David Zimmer. Ishan Baba and David Zimmer will be making oral arguments on behalf of the team. Respondent Rebecca Andrews, the Dean for Science and Engineering at Ames University, is represented by the Harper Lee team. Kristen Bateman, Douglas Braley, Eric Wynn, Elise Schneiderman, Philip Tedesco, and John Benjamin Ward. Eric Wynn and John Benjamin Ward will be making oral arguments on behalf of the team. The Honorable Stephen Breyer, Associate Justice of the United States Supreme Court, will preside as Chief Justice of this final round argument. Joining him will be the Honorable Marsha Siegal Berzon of the United States District Court for the Ninth Circuit, and the Honorable Frank Hull of the United States District Court for the 11th Circuit. We ask that you please hold your applause until all oralists have finished speaking. And please also remember that the petitioner will make rebuttal arguments after the respondent has spoken. Please also note that no photography of any kind is permitted at any time while the justices are in the courtroom. And please remain seated while the oralists are speaking and turn off all cell phones if you have not done so already. Best of luck to both teams, and everybody enjoy the argument. Thank you.
The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable the United States Supreme Court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Right. Here we have the case of Hubbard against Andrews, and lawyers are ready. Go right ahead.
Mr. Chief Justice, and may it please the court. My name is Ishan Baba, and I, along with my co-counsel David Zimmer, represent the petitioners Sophie Hubbard, Jeanine Lopez, and Hector Betancourt in this matter. I will argue that respondent violated petitioner's First Amendment rights when she removed the online roundtable containing petitioner's paper from the internet. And Mr. Zimmer will argue that respondent violated petitioner Betancourt's 14th Amendment rights by placing false and stigmatizing charges in his personnel file without affording him a name-clearing hearing. We'd like to reserve 3 minutes for rebuttal. Your Honors, this case arises in a university, a context this court has noted as the quintessential marketplace of ideas and occupying a special constitutional niche. For two reasons, respondent's restriction of petitioner's speech was unconstitutional. First, the university created a designated public forum, and as petitioner's speech fell inside the forum's designation, it should be judged under the strict scrutiny standard. Under this standard, respondent's restriction cannot stand. Second, if this court determines that the online roundtable was not a designated public forum, but rather a non-public forum, then the standard from Tinker should apply, and again, respondent's restriction cannot stand under Tinker.
Is there any case in which a court has taken a website, basically, or a server as being a forum at all?
Your Honor, a number of courts have noted that a forum, and this court indeed as well, that a forum not necessarily has to be a physical thing. I
understand that, but this is, it seems to me, somewhat different, and I'm wondering whether the forum analysis is even useful at all, because a server is essentially fungible. I mean, it could be a different server. They could have gone off and put the same website somewhere else. It's somewhat irrelevant, isn't it, whether it's on a server or isn't on the server, on the university server as opposed to somewhere else?
Well, Your Honor, I would say the Fifth Circuit in Putnam Pitt has recognized that a bulletin board, for example, can have many of the aspects of a public forum. So that is one court that has analyzed internet sites in a forum analysis. But it's not clear that Respondent would have allowed Petitioner to post their paper anywhere else. Indeed, the concerns that Respondent cites regarding the paper don't have to do with the imprimatur or the idea that the university would somehow be badly associated with the speech, but rather have to do with the content.
Exactly. Which is why I'm wondering whether the forum idea has anything to do with this.
I think it does, Your Honor, because the forum analysis allows this court and allows the lower courts to set the balancing standard between the university's regulation of speech on its own property and the individual's right to free expression. And without the forum analysis, which even in an internet context where so much communication continues to this day, a forum analysis allows that balancing test to take place. And in fact, this court noted in ACL v. Reno the extent to which the internet is the quintessential democratic forum for the free exchange of ideas, making the university's restriction, especially on the internet, so antithetical to that notion.
Well, what's a forum?
Excuse me, Your Honor?
What's a forum?
The forum in this case, Your Honor...
No, but I mean, I don't know what it is. I mean, I understand what a park is. A park is a place where historically people have had a right to demonstrate. You got me that far. And probably that's true of a lot of streets, too. But I don't know how you get me any farther. I mean, is a classroom a forum? Is this a forum? I mean, what's a forum?
Your Honor, I think a forum is a place where petitioners or individuals in general seek access to speak. And so
well, that's true in every class. So is every class a forum? I mean, they used to. Maybe now a lot of the students don't want to speak. But it used to be there are a certain number, anyway, who always want to try to speak, and the others don't like them that much. And so, but in any case, is that a forum?
I think, Your Honor, a classroom could be considered a non-public forum, yes.
So the classroom is a forum?
Yes.
Okay, is my dining room table a forum? I have these children always trying to speak.
Well, Your Honor, if you represent the government, then that could be a forum, but...
So is the GSA cafeteria a forum?
It is a forum, Your Honor, yes.
Well, then everything is a forum, I guess. So where is that getting us with talking about a forum?
I think a forum analysis is important, Your Honor, because it allows for the balancing test, and in order to determine all the different...
What do you mean it allows for a balancing test?
Well, it allows this court and lower courts to analyze the government's interest in restricting speech from the individual's right to free expression and a way of putting all the different tests for free speech, be it strict scrutiny, Tinker, Hazelwood...
Now, suppose the government just says, look, I have some welfare payments I'm giving to people. Is that a forum?
Not unless,
no.
Your
Okay.
Honor.
So what they say is, by the way, I think I'm only going to give it to Democrats. Is there a free speech problem with that? Is there a First Amendment problem there?
Your Honor, I think it would depend whether or not
No, I don't like Democrats, or I don't like Republicans, so I'm just going to give them to people in the other party. And the reason is I wish they'd shut up with talking about their party when I have the good party, okay? So now, do you feel any problem? There's a First Amendment there, interest in there, isn't there?
Your Honor, I think it would depend whether it was the government speaking, and this would be a Rust v. Sullivan
No,
situation.
what the government does is the government says, I'm going to give welfare benefits to my friends, the Democrats, because I don't like that other party. And next time, they'll learn not to talk so much. There's no problem with the government. That's what they did, okay? Now, you have a problem with my saying that there's a First Amendment problem in that.
I think when the government is conditioning a benefit on the expression of a particular political belief, then yes, there would be an issue there.
Fine. And so what I'm showing you is you don't need this word forum in order to recognize First Amendment problems and begin to look to see if somebody's hurt and there's a legitimate government interest. Now we're back at Judge
And
Barzon's
shouldn't you
question.
be focusing on the nature of the speech to begin with? What is the nature of the speech here? Is it political speech? What type of speech is it?
This is
Begin with.
scientific speech, Your Honor.
It's scientific speech. It's speech, isn't it criminal facilitating speech?
Your Honor,
Tells you how to hack into the system and facilitates criminal activity. Is that the nature of the speech?
No, Your Honor. With respect, the petitioner's speech is the heart of the kind of academic dialogue that takes place in universities and is so crucial to protect.
Is it not true from the record that the paper details exactly how to hack into the system?
Your Honor, the paper does contain information regarding the problem, which is the underlying security vulnerabilities.
And the university has no interest in protecting that
Your Honor,
issue?
the university has an interest in protecting the network security, and the best way to do that is to fix those vulnerabilities, not to suppress petitioners' speech. In this case, what's endangering the IT security
So
of
it's
Ames
just academic speech. That's all it is.
It's an academic speech on scientific topics, which is something that even Justice Jackson recognized in Jeanette as being crucial within the First Amendment. Simply because it's not political speech doesn't mean that it should lose First Amendment protection, especially in a university setting where the free exchange of ideas is so crucial.
And how do we look at the internet usage rules? Do we give them any deference at all? Do they have right to have rules about access to the internet here or the website?
Certainly, Your Honor, the internet guidelines are...
So they do have some power to have rules. You will concede that with regard to access.
Oh, absolutely, Your Honor. The university can have the guidelines that it does, and they form when the university creates the designated forum, the reasonable guidelines, which petitioner believes are reasonable, form the boundaries of that designation. So
do you understand what your clients do to have violated the guidelines?
No, Your Honor. We do not believe that the speech of our client did violate the guidelines. It was speech that sought and presented to the university a means of protecting itself and closing the underlying security vulnerabilities that the university had left open since 2005. This speech was very much to do with protecting the rights of individuals at the university.
But is that why it didn't violate the guidelines, or is it because the guidelines really weren't about the content of the documents? The guidelines were about the use of the physical servers, but it wasn't really. Do the guidelines say anything about content?
Well, the guidelines refer to speech that doesn't protect the integrity of the system or violates the rights of others.
But aren't the guidelines content neutral, viewpoint neutral?
Yes, Your Honor.
So the guidelines, so the university, it's academic speech. They have some right to regulate. You concede both points. Is that correct?
That's right, Your Honor, yes.
And the guidelines are reasonable. So are we left with, there's just a factual issue about whether your speech violates the guidelines? Why is that not the issue here, really, as opposed to First Amendment issues? Just a factual issue of whether your speech violates the guidelines.
Your Honor, the question of whether or not the speech violates the guidelines is, for a start, a question the district court never addressed, and therefore, if this court determines it's dispositive, it should remand to the district court for an analysis.
We're in summary judgment, right?
Excuse me, Your Honor?
Aren't we in summary
Yes,
judgment
that's
here?
correct, Your Honor.
So aren't we reviewing de novo on the record?
That's correct, Your Honor. Issues of law, but this is an issue of fact as to whether the content of petitioner's speech violated the nature of the guidelines, and that's something that the district court never addressed in her opinion. But in addition, the question of whether or not the speech violated the guidelines would only determine whether or not it falls within the forum's designation and should be protected under strict scrutiny, or whether it falls outside the forum's designation. And then petitioner argues that outside of a forum, speech should be treated as if it's in a non-public forum, and there the standard from Tinker should apply. The baseline standard this court has applied in academic.
Forgetting the cases for a minute, as I read their brief, what they're saying is this, that your clients had a document, and if we put that on the internet, that document would teach students and anyone else who looked at it how to break into our computer system, which would compromise people's social security numbers, which would enable them to get all kinds of private information about our students that the students might not want others to have, and the result will be very harmful to the people who use this. So we said, don't put it on, okay? We're not going to let them put that very harmful information on our computer. Now, what is it in the First Amendment that says they can't do that, and why?
Your Honor, what it is in the First Amendment is the strict scrutiny standard that this court should apply in this case. Under the strict scrutiny standard, the restriction is only allowed if it's necessary to fulfill a compelling governmental interest and is narrowly tailored. And for the same reason, when this court in Brandenburg, for example, dealt with what was allegedly dangerous speech but said this does not meet the appropriate standard, petitioner speech is the same way. In addition, though Respondent does...
Was it Brandenburg criminal sanctions? The government was imposing criminal sanctions in Brandenburg. Wasn't that the issue there?
That's true.
Which is totally unlike this case where they're just trying to say you cannot put the paper on the website that shows how to hack into the system.
That's true, Your Honor, though courts have applied...
There's no criminal sanction here.
There is no criminal sanction
here. In
here.
fact, they say you can post it as long as you take out the privileged information about how to get into our system. Is that not the case?
The latter thing Your Honor said is not the case. The university removed the entirety of the paper and, in fact, the entirety of the round table and never consulted petitioners.
But didn't they say, and if you redact the infringing part, you may put it back up?
No, Your Honor. They asked to pull down the entire paper of petitioners, never indicating that there was, in fact, valuable parts of the paper. And indeed, Justice Breyer, the Chief Justice Breyer, the parade of horribles that Respondent cites allegedly from petitioner's paper has no basis in the record beyond 6 words in the complaint. And in fact, in the 6 days after Petitioner's paper was posted, before it was pulled down, there was no record whatsoever of any harm coming to the university. 3 professors who read the paper in their independent capacity as judges of the competition obviously judged it meritorious enough to win, and the only advertised prize was posting on the website.
Isn't the fact of the matter is Brandenburg doesn't apply because that was criminal sanctions. Hazelwood doesn't apply because it's a high school. And there is, in effect, basically no law that is in point here. Would you concede that?
No, Your Honor. We believe that...
What's in point, then? What case is most like your case from Supreme Court, not lower courts?
Well, Your Honor, the standard from Tinker has been applied by this court.
But you said this is not political speech. Tinker spoke at length, emphasizing it was political speech, a black arm plan.
That's true, Your Honor.
So Tinker doesn't apply, isn't that correct?
No, Your Honor, I don't think the Tinker standard need only be restricted to political speech. Tinker made clear that it was the personal expression of students.
So what is the case most like your case?
Well, from this court's jurisprudence, which has not dealt with that many student speech cases, I think the standard from Tinker for independent student speech...
But isn't that the whole point? There is no prevailing precedent here.
Well, there's certainly no governing precedent, Your Honor, but there are standards that this court can apply that are analogous, and I think...
Would this case be any different if it didn't involve the university's IT system at all, but instead, for example, was a sanction, it was on a private website, but the sanction was expulsion or some sanction of the students for publishing this paper? Would that make any difference in terms of the actual underlying interest as opposed to fitting into some categorization, form categorization?
Well, I think...
In this instance, in my hypothetical, you wouldn't apply a form analysis, right? Because it wouldn't be the university's property. Does that change anything in terms of the underlying interests that are really at stake here on both sides?
Your Honor, it may not, in the sense that if the university took punitive action against the students for expressing their First Amendment opinions, then surely one of the tests from this court's jurisprudence would apply. But as this takes place in a university, though the concerns, I think, are very analogous, the forum analysis structure allows university administrators and students a means of structuring the expectations for speech and also determining what sorts of regulations which will take place. And I think this is crucial, especially in a university setting where the free exchange of ideas is so important and expectations of what kind of ideas will be shared.
The lower school cases really never explain how they intersect with the forum cases. They're kind of 2 lines of authority that don't seem to be passing in the night to some degree, and you seem to want to buy into the school line of cases, and why is that useful to you?
I think it's useful, Your Honor, just as a means of structuring the inquiry as to which of the multiple tests that could be used for student speech is appropriate. I think in a classroom setting, there's no question that the university or a lower school can exercise greater discretion over student speech, and potentially in a situation where, as this court in Cornelius noted, the policies and practices of the university indicate that it's having a greater degree of control over student speech. There, it would be unreasonable to say to the university, you should apply the same standard there as you do in a situation where you create a forum for the pure private expression of students. So I think that's why the forum analysis is important in this case, not because it's dispositive, but it does allow structuring all of these different tests and giving the lower courts and giving students some idea of exactly the freedoms that they will have.
So if you were to suggest how we should write our opinion, you think that we should use the existing structures in some fashion?
I think it would be useful, Your Honor.
Or should we say the Supreme Court cases are a muddle and provide no guidance?
Well, muddled may be...
That's quite commonly the case.
I think muddled may be harsh, Your Honor, but certainly the cases are...
Well, let me ask about an allegation in your own complaint. Going back to the record, you allege and you would concede that your paper demonstrates ways in which hackers can take advantage and get into the system to cause serious disruption to Ames. I will accept Tinker for purposes of this argument. Why would this not satisfy even your own Tinker standard, if that's the most relevant precedent, by your own complaint?
I see my time is about to expire, may I?
You may answer.
Answer the question.
Your Honor, the reason this wouldn't satisfy Tinker, and this court clarified in Healy that it needs substantial evidence or a substantial threat of material disruption, is that the underlying harm here is the internet vulnerabilities the university has left open since 2005. Petitioner's speech was an academic dialogue aimed at presenting to the university means of closing those vulnerabilities.
As we say in court, you've answered the question.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the Court. My name is David Zimmer, and as my co-counsel, Ishan Baba, stated, I will argue that when Respondent placed false and stigmatizing charges in Betancourt's personnel file that could be accessed by potential future employers, Respondent deprived Betancourt of a protected liberty interest and thus owed him due process of law. Your Honors, because this Court has instructed the parties to assume that the charges in this case are stigmatizing, the sole question before this Court today regarding Betancourt's liberty interest is whether Respondent publicly disclosed the charges against Betancourt under this Court's holding in Bishop v.
Were the
Wood.
questions presented drafted by the court? Is that our understanding?
Well, Your Honor, the question presented in this case was the question that Petitioner is worded in exactly the same way as the question Petitioner presented in the appeal. So presumably, it's unclear exactly, but presumably this Court adopted Petitioner's wording.
Okay.
Indeed, therefore, the sole question before this Court today is whether or not the charges in this case were publicly disclosed under this Court's holding in Bishop v. Wood. And for two primary reasons, this Court should interpret public disclosure to include the placement of charges into a channel that could lead to their dissemination. First, in Bishop v. Wood, this Court reasoned that charges are publicly disclosed as soon as they leave a public employee less free than before to pursue new jobs. Because each job application that Betancourt filed could trigger the release of false and stigmatizing charges against him by the...
By the way, why is this false?
Your Honor, the charges in this case are false, as the district court found, because Betancourt could not have been acting in an insubordinate fashion because he was not acting in his capacity as an employee of the university when he refused to remove the paper from the round table. Betancourt was acting in his capacity as a graduate student and as the editor of the website of the round table.
I thought Bishop v. Wood, I might be misremembering it, but I thought it was a case which the defendant won.
In which, that's true, Your Honor.
So how does it help you?
Well, Your Honor, the reasoning in Bishop v. Wood, the charges were made against the plaintiff orally and in private by his supervisor. And this Court reasoned in Bishop that in a situation in which charges were not publicly disclosed and in which the individual was therefore as free as before to pursue new jobs, that in that case the individual could not make out a liberty
But
deprivation.
the facts are Bishop, it was only an oral communication. There was nothing in writing.
That's true, Your Honor.
So Bishop tells us nothing.
Well, Your Honor, it's true that Bishop, in the specific holding of Bishop, sheds very little light on what public disclosure actually means. But the idea and what Petitioner is arguing is that the reasoning in Bishop, that the way that Bishop got to its public disclosure requirement was as an attempt to weed out cases in which individuals effectively had not been in any way prevented from pursuing new jobs.
So how is this supposed to work? If a lot of people teach, there are a lot of probationary teachers, and when you want to promote a probationary teacher, it's normal for the faculty to get recommendations from people. And so are you saying that any negative recommendation, before you can use it, you have to tell the individual and have a hearing? I mean, if you have to have a hearing and the person who says, you know, I thought that he was a terrible teacher. Indeed, I don't think he showed up to class until it was at least 15 minutes after the bell rang. And moreover, he was snoring quite a lot of the time. Now, are you saying if somebody were to say something like that, then you'd have to have a hearing before the rest of the faculty could use it, and that the Constitution of the United States insists on that?
Not at all, Your Honor. And
what are you saying?
There are two reasons in which the situation Your Honor suggests would not require a hearing. Under Paul v. Davis, the charges must be made in conjunction with a change in tangible legal status. So
Yeah. You see, we looked into this because we're thinking of giving this individual tenure. So that's quite a change in status.
Okay. Well,
so now, I'm back to my question.
So the other issue, Your Honor, is that it's not simply any negative evaluation that would require a hearing, but only when charges rise to the level of stigma, as this Court established.
Oh, well, my goodness, snoring in class?
Well, Your Honor, this Court...
That's going to be hard to get a job anywhere you start snoring in class. It suggests that you're asleep.
It does suggest. I haven't met anyone who snored while awake. It's true, Your Honor. But the issue is that even that, a negative evaluation along those lines would not actually rise to the level of stigma.
So, in other words, it's not a problem if you say whatever it was. A joke has gone far enough. But but you say here, what was the language here? The language here was he was in. What was the word? It was in.
The charges in this case were insubordination, making inappropriate comments.
All right,
to
making
students.
inappropriate comments. Fine.
And
Insubordination, they meant, I think, that, well, I don't know what they meant about that. I don't know if that's serious or not. I guess it might be, might not be, hard to say.
Well, again, Your Honor,
Do you think this, is that what this turns on, whether this is better or worse, or?
Well, Your Honor, the question of whether or not the charges rose to that level of stigmatizing is not the question presented before this.
It is, though, very hard to think about this case without thinking about that, because, in fact, you have, I mean, the stigma would have to be attached to the increment between what he actually did and the fact that he did it in one capacity rather than another, which doesn't seem very stigmatizing at all. So it makes the case hard to think about because, although I think you're probably right that the issue wasn't properly raised, it's not a very useful way to consider what a really stigmatizing statement would look like. Like he murdered somebody. You might think quite differently about that.
That's true, Your Honor, and I think that the key point is that the stigma inquiry and the public disclosure inquiry are separable in the sense that there is a question of how bad the charges are, how stigmatizing the charges
and you
are.
don't think you might take a different view of the public disclosure question depending on how stigmatizing? If the document said he murdered somebody, you might think, well, he should be able to challenge that at the outset. But if it was a more incremental thing, you say, well, let's wait until it actually makes some effect, has some effect.
Well, Your Honor, I would actually disagree with that in the sense that even a slightly smaller charge, if it rises to the level of stigmatizing, if it is publicly disclosed, would significantly infringe on the individual's ability.
Oh, wait, we're back to my question. What is it? What is the answer? I've read a lot of tenure applications. People are pretty rough sometimes in those applications. They say, his work is original and interesting. What's interesting is not original. What's original is not interesting. That's a famous. All right. But people say things like that, and they think it's funny. But the point is that people can be very, very rude. And my question is, are you telling me that all these tenure applications and files, which are kept, that the Constitution of the United States requires that there be a hearing as to each one? Is that what you're saying?
Well,
yes
no,
or no?
It's not, Your
No.
Honor, in the sense that
Well,
yes or no?
Harvard.
Sorry?
Not at Harvard, because it's a public
No, well, not at Harvard, obviously. But also, in addition, Your Honor,
University of Michigan. Do you want to say yes or do you want to say no?
No. The answer is no, Your Honor.
The answer is no.
And in that situation, when the charges are used internally, there's no question that there's no argument that a hearing would be needed. The question is if that university were going to release those charges to other employers, that is when the danger arises.
So that gets us back to public disclosure. How can you argue there's public disclosure here when your client hasn't applied for a job? Nobody's asked for the recommendation. Nothing has happened yet. It's only in the file.
Well, Your Honor,
The very minimum part, it's just been placed in the file. How can that be public disclosure?
Well, Your Honor, public disclosure is not necessarily involve a third party accessing the charges, but is the act of making those charges available.
They haven't been made available.
What's wrong with the proposal that you wait until somebody's asked for it, and then you have a hearing?
Well, I think the issue with...
If you want to disclose it. In other words, I know that you quarrel in your briefs about the third partiness, but it really isn't third party. It's if somebody asks for it and the university is prepared to disclose it, has made a decision to disclose it, then you could have a hearing. What's wrong with that?
The issue with that, Your Honor, is that, there are two issues with that, Your Honor. The first is that the actual deprivation, the thing that actually impacts the individual's ability to pursue new jobs is the placing the charges in the file, because it's at that moment that the individual is actually less free than before to pursue new jobs, because it's at that moment that they are forced to decide to either protect their professional reputation by not applying to jobs or to risk their professional
How does that affect me when I don't know it's there?
Well, Your Honor, in a way, it's even worse if you don't know that it's there, because then you could apply to jobs not realizing that you're being put in a situation where each application you file could trigger the release of these charges.
You're asking for a rule that makes public disclosure at the time of the placement in the file. I just want to understand what your position is. Is that your position? At the moment it's placed in the file, it's public disclosure.
It's publicly
disclosed. Is that correct? Yes or no?
It's correct. Yes, Your Honor. It is correct in a situation where those files could be accessed by members of the public. And in this case, the university's privacy regulations allow other public institutions to request those files and allow the university to release those files. And thus,
So you don't think it makes any difference at all? Suppose if here the regulation is kind of indeterminate. They may or may not release it. And shouldn't that make a difference as to what the rule is about when you have to have a hearing, if you have to have a hearing? I mean, it might be different if the regulation said, and if asked by a public university, we will release it. But that's not what it says.
Well, Your Honor, it doesn't say that. However, it also provides almost no guidelines as to when the personnel files will be released. They're in an indeterminate number of
It's purely
people.
discretionary with the file custodian.
It's purely discretionary. That's true, Your Honor.
And they don't even acknowledge or is required by the general counsel if they want to go. But the file custodian is not required to seek general counsel approval. Is that correct?
That's true. They're not required
So it's
to
totally
seek-
discretionary. It goes back to the judge's question then. We don't even know here whether discretion will ever occur.
That's true, Your Honor. However, given the fact that
So why shouldn't we wait until actually discretion is exercised and they propose to release it, but they notify your client first and have the hearing then? Why would that not adequately afford due process here?
the reason that would not is that a standard like the one Your Honor is suggesting would be entirely unenforceable by individuals like Betancourt. This is exactly what the Fourth Circuit noted in Cialino, that Betancourt would have to apply to jobs knowing that these false and stigmatizing charges were in his file and would not necessarily be able to verify when a request from a potential future employer came in.
And to go back to some of the questions that Chief Justice Breyer has been asking, suppose they'd written nothing in the file, but that when he applied for a job, they called the person who put this in the file, and they said, what do you think of this guy? And she says he's insubordinate. Well, he's certainly never going to know that.
That's true, Your Honor, but that would be,
Would he have to have a hearing over that?
in the case where that person did actually disseminate those charges and make
Right.
those statements, then they would absolutely require
So
a hearing.
it doesn't depend on the writing then?
Sorry?
It does not depend on the writing in a file. It's just an opinion from anybody at the university called for a reference.
Well, no, Your Honor. The distinction is when charges are actually disseminated, when the charges are actually distributed to potential future employers or to any member of the public, I don't think there's any debate that at that point that would constitute public disclosure. The issue is in determining when something less than that would constitute public disclosure.
But what difference does it make as to whether there's public disclosure, whether there's a piece of paper in the file or there isn't a piece of paper in the file? I mean, you agree if there's no piece of paper in the file that any right is triggered at the point that somebody is going to disseminate the information. So what difference does it make that this piece of paper is sitting in the file?
Well, Your Honor, to individuals like Betancourt and those who have false and stigmatizing charges made against them by the state, it makes an enormous difference. And indeed, one of the purposes of the Due Process Clause is to make individuals feel like government is treating them fairly.
Right, but what I'm trying to say is this. This person who has this false idea in their head is still walking around with the false idea in their head. You're not going to have a hearing about a false idea that's in somebody's head, right?
No, of course
Until
not.
it becomes co-ate in some fashion. So why is it different whether it's a false idea in somebody's head or a false idea on a piece of paper in a file that's not going anywhere?
Well, Your Honor, I think the issue is that it's entirely unclear whether or not that file is going anywhere. And indeed, there's nothing that would suggest that as soon as Betancourt applied to a job, that it wouldn't that day, under the university's privacy regulations, be released to that potential.
But that's also true of the idea in somebody's head.
That's true, Your Honor. However, we recognize that we obviously can't provide hearings every single time somebody has an idea. But when the university takes affirmative action, when the university takes a concrete step that makes false and stigmatizing charges available to the outside world, to the public, and specifically to institutions to which this individual may be applying, in that situation, an individual's ability, their liberty to pursue their chosen occupation has been significantly impaired.
Why? That is, when you think about this, I can't really find a case that says there's any such right at all. I mean, Wood says it by implication, and I know there's one involving a liquor license or a right to drink liquor or something. Why should there be a right like this in the Constitution? After all, if somebody goes around and lies about you, there are laws against libel and slander. At this very moment, there are probably 50,000 people applying for 2,000 jobs in a new administration, and there are people all over the place saying terrible things about half of them. And a lot of them could end up in the newspaper. And there are people every day in welfare agencies who say very unfortunate things about some of their clients. There are a lot of people hurt by bad words. Why, of all the people that might be protected, do we decide that people who want to teach in a university are the ones to have this right? I mean, what is this right anyway? I don't understand it. So why don't you explain to me what it is in a world where people could sue for slander or libel when they're hurt? Why does it even exist if it does?
Well, first of all, Your Honor, this court has recognized this right quite clearly in in Bishop, but also
I would say, all right, you know what we
sorry,
think
well-
of Bishop. I can't really do it. It's hard to get a right from negative implication, but I'll go back and look and see what they say.
But in Owen v. City of Independence, this court actually affirmatively recognized a right upholding an individual's claim under just such a case. The public disclosure was not an issue, but it was this underlying right, this underlying liberty.
Just such. What do you mean, just such? It was a professor, or what was it?
No, it was a police chief, Your Honor. So this in no way would be limited to universities. It would involve all public employees, and it involves all situations in which public employers basically put stigmatizing lies into personnel files that they could then, under their own procedures, release to potential future employers. This court in Owen specifically recognized a right to pursue a chosen occupation in exactly the way Petitioner is suggesting.
But hadn't the police chief in Owens been terminated and the file had been requested and had been turned over? And he had a claim for 1983 for damages. Isn't that the facts in Owens?
Absolutely, Your Honor. Owen had
And
nothing.
none of that happened here. Nothing's been released.
That's true, Your Honor. Owen did not involve a question about public disclosure. The sole point was that Owen did recognize this type of liberty interest claim. And I think that the issue is that once this claim is recognized, once it's recognized that one has a right to pursue one's chosen occupation, that right would be meaningless if the state is allowed to interfere with the actual act of applying to jobs by
One
threatening.
interesting thing is that my understanding of the common law resolution of the same problem is kind of the opposite. It is that there is a privilege, isn't there, with regard to these kind of employment inquiries, largely.
Your Honor, I see my time has expired.
You can answer.
Yeah. The difference in this case, Your Honor, is that what is being requested here is not a substantive outcome. It's actually it's the due process, the right to feel on these individuals' parts that they're being treated fairly, that they're given an opportunity to present their side of the story, and to have the government at least.
And that's my last question, if I may, which is, what kind of a hearing do you think that there should be? You're very vague about that in your brief, and obviously there's myriad cases about what processes do, and that may matter as to our ultimate resolution here. Are you just saying that they had an obligation to let him write his own letter to the file disputing it, or did they have to have a hearing with a hearing officer and witnesses, or what?
Your Honor, under this court's decisions, I think that the nature of the hearing could be very much discretionary on the part of the university, and would simply have to have some sort of neutral arbitrator and allow Betancourt to present.
So you wouldn't be satisfied with simply the right to write a contesting letter to the file?
No, Your Honor. I think that would not be sufficient, but almost anything beyond that would be.
But some of the Supreme Court's due process cases seem to contemplate something like that.
That's true, Your Honor, and even that would be infinitely more process given the zero process that Betancourt was afforded in this case. But I do think that the preferable would be an opportunity for Betancourt to at least contest the underlying facts and to make some claim to a neutral arbitrator. For all of these reasons, we would urge this court to overturn the Court of Appeals.
Thank you
very
counsel.
much.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. The parties agree that the paper on the Roundtable webpage provided a detailed step-by-step set of instructions.
Well, where do the parties agree to that? First of all, you rely a lot in your brief on the complaint, and as I understand, the complaint it's not a verified complaint, is it?
So the petitioners concede that in the complaint, and they also conceded that just now in oral argument, that the paper contained detailed step-by-step instructions on how to hack through.
They didn't say that. They said it had some detail. It's very hard without the actual document to tell what we're talking about here, but there's a big difference between, the level, whether it's at a level of detail that people could actually go ahead and do it, as opposed to descriptive enough to explain the problem, but not really to allow somebody to follow it. And there's no way to tell from any of the documents we have which it is.
I think there is a difference between those two types of documents, and the petitioners, again, say in their complaint and have not challenged at all throughout this process that the paper does, in fact, contain detailed instructions on how to.
Did they ever use the word instructions?
It says it has a detailed explanation.
Right. They never use the word instructions. You're the one who's using the word instructions.
The petitioners do say that it would enable hackers to follow the explanation, to hack through Ames State's network security, shut down.
Where do they say that? Not in the complaint, but in the facts that we're dealing with on summary judgment.
The parties filed a joint statement of stipulated fact that's found on page 27 of the record.
Yeah. Where does it say that this would allow somebody to actually hack in?
It said that. It says that they included, this is 3 lines up from the bottom, a detailed explanation of how hackers could attack the Ames U system successfully.
And I don't read that necessarily. It's an explanation, but it doesn't mean that somebody could actually do it by following this.
Well, they've said that the explanation would leave the Ames state system particularly vulnerable to sophisticated black hat hackers who troll internet websites.
And where does it say that? I actually had a lot of problems with your brief for this reason, because I thought you were overstating the record substantially. Where does it say what you just said?
That's in footnote 2 on page 27. It says that the system continued to be vulnerable to attack by black hat hackers. It explains what those black hat hackers try to do.
Where does it say that this document would allow the black hat hackers to do anything?
The language is, again, 3 lines up on page 27, a detailed explanation of how hackers could attack the system successfully. So the petitioners evidently thought that by following their explanation, hackers could attack the system successfully. And they say that by hacking through the system, they could shut down all campus security, they could access confidential personal information, and they could cause, quote, serious disruption to the university.
Where is that? That's all in the complaint, right?
It is, of course, in the complaint that the petitioners filed.
Right, and that's not a fact before us at this point.
Your Honors, that is an assumption that the parties have made based on the complaint, and the petitioners have not contested, even in the reply brief, that any of the factual assertions are incorrect. The threshold issue before the court...
Even if the paper has an explanation of how to hack in, the petitioners argue that the focus of their paper is how to correct those problems to prevent that from occurring. So you disagree on the focus of the paper, where the intent is to prevent occurrence or to enable occurrence. Isn't that correct? You dispute what the focus of the paper is.
We do not dispute that the paper did contain valuable information that identified the problem for the university.
So at a minimum, it has dual purposes.
That's correct.
All right, and isn't it necessary to say how to fix it, that you must explain what the problem is?
I think that's true.
And don't they have a right to criticize the university for not protecting their private information? They have that right to criticize,
They
correct?
certainly do, Your Honor.
And they have a right to say it should be fixed.
That's correct.
And they have to identify the problem necessarily to say how it should be fixed. Isn't that correct?
Well, that is
Now, I'm not getting the First Amendment. I'm just talking about the facts.
In a general sense, that's correct.
Okay, so what's the problem here? Why is it not protected speech to criticize the state with regard to what they're doing wrong?
The threshold issue, as you indicated in a question to Mr. Baba, is whether the paper as a whole, the roundtable page, complied with the university's internet usage guidelines.
Why is that? I mean, your interest in this paper has nothing to do with whether it's on your website. You would be just as upset if it was on somebody else's website.
I think that's true. The question before the court today is whether the Constitution forces a university to host information that could be very threatening to students on campus.
But that doesn't seem to be a useful inquiry, because your interest in it has nothing to do with control of property. The whole forum notion has to do essentially with, we have some property and we get to control it. That's not what you're upset about. What you're upset about isn't, it's the content of this document wherever it was. And not only that, it's not even directed at people in the university, it's directed at the world at large.
We think it is
and accessible by the world at large because it's on the internet.
That's true. Of course, the paper does contain an explanation of how to hack into Ames State's network security.
And if it was on AOL, you'd be just as upset.
I think that's true.
But you'd be upset, but you couldn't do anything about it.
I think that's right.
You couldn't take it off AOL.
I think we'd have to meet a higher level of scrutiny to be able to do that.
So here the issue is, could you take it off your own website?
I think that's right. And again, the question before the court is whether a web page that gives an explanation of how hackers could shut down campus security, could shut down network security, whether that really complies with the university's internet usage guidelines.
The first question before the court is whether we look at this internet access through this prism of the forum doctrine, or whether we look at it essentially as governmental censorship at large.
I think the university created an amount of web space in which students could post information, could discuss issues. In that sense, it created a forum. It then, as this court said it could in Rosenberger, created a set of limited guidelines that the petitioners would have to comply with, or else their speech could be excluded.
Suppose this was a faculty person publishing a paper on Marxist economics. Could the university tell them they have to take that off the website?
I don't think under the limited public forum guidelines they could do that. That wouldn't, of course, threaten the access and integrity of network resources, as this paper did.
And if they publish something that might have encourage terrorism in some fashion, they couldn't take that off either?
They might be able to if it was going to incite imminent terrorism under a different standard.
Then you're applying the Brandenburg standard.
That's a different standard.
But you're trying to avoid the Brandenburg standard.
I think in Brandenburg, the court laid down a blanket principle. In any forum, at any time, if a speaker encourages or incites imminent violent behavior, it can be limited.
But you don't want us to apply Brandenburg.
No, the court has come up with a number of other tests. For example, in Rosenberger, it said that the government is allowed to create reasonable forum rules. For example, in this case, I think it's important to recognize the consequences. If a university cannot tell its students, we're going to provide you with computers and email accounts and internet access, but you can't use those resources to distribute hacking explanations that would allow other people to steal students' information.
You're therefore making a distinction for some fortuitous reason between hacking explanations and what if what was on here was how to sell marijuana? That wouldn't violate the internet rules, so that's okay?
I think under the limited public, if the court decides under the limited public forum rules, that would not violate those rules.
I don't understand how this violates those rules.
So the rules are found on the second page of the appendix of the red brief.
Yeah, and obviously what they're directed to is actual actions that compromise the internet system. It's not directed at content, and it oughtn't to be.
Well, the actual text of the rule is that the students must protect the access and integrity of computing and information technology resources and respect the privacy and personal rights of others. The specific question before the court is when you post a paper that gives a detailed explanation of how to shut down campus security and steal other people's personal information, whether that really complies with the regulation that you agreed to that says you must respect other people's privacy rights and you can't violate.
Their position is that the problem isn't what they're saying, it's the state of the system, and that if they don't expose it, somebody else is going to find it out anyway, and that they're trying to fix it.
I think that's partially correct, and we're very appreciative that the students have brought this problem to our attention. The question is, while the university is trying to implement those security fixes, whether we have to force the university to leave those instructions, that explanation up.
Let's switch a bit to the burden of proof. You're the move-ant, and you have the burden.
That's right.
That's correct. And to show undisputed facts entitle you to judgment as a matter of law.
That's right.
Why in the world would we decide this case without the actual paper in the record and not vacating remand, as the Supreme Court often does, for further development of the factual record? Why is that not the answer to this case?
Your Honor, I think if the university were the only one in the record to have described the paper and the specific things that the paper does, we might have to remand. Of course, we'd be comfortable with that, given the facts that we know in this case.
So you're fine with vacating and remanding?
We don't think
in this
that
case?
We would be okay with that, but we don't think it's necessary.
Is there any finding that, or could you make a finding on the current record that in fact somebody could hack in by reading the paper?
Again, on page 27, the petitioner stipulated to the court that it would allow hackers to successfully attack the Ames State network.
Okay, so then is that the solution? The reason they keep talking about forums is because they think the university here has told all kinds of groups that they can put all kinds of things on this computer. And they might think, you start looking at what's on that computer, oh my God. So all of a sudden, out of all those things that are there, including some that are probably properly labeled, oh my God, this one they object to. And they didn't go say, why don't you just cross these parts out? They didn't see if they were willing to make it a little harder to get for the hackers who want to destroy everything. And we don't even know what it looks like. So why not tell the district court judge, here's what you do. First, go get the paper and read it. Second, go look and see the other kinds of things that are on this university thing, and then make a judgment about whether the stuff in this paper is significantly more dangerous and harmful to privacy or social security numbers than all this other stuff that you're perfectly willing to put up with.
I think, Your Honor, based on the detailed concession that the petitioners make in the complaint and our own review of the paper, we're comfortable that on remand, the district court would find that it clearly violates the Internet guidelines. Of course, it's important to remember the type of danger that this paper posed.
But a distinction they pose is that we're not advocating hacking. We're just telling you how to go do it.
I think
And why isn't that a material distinction?
I think it's not, because it doesn't change the fact that.
But there's no advocacy here. You agree?
I agree.
with
There's
that?
absolutely no advocacy.
No
here.
advocacy of violence.
Agreed.
So it wouldn't satisfy Tinker. Is that correct?
It could satisfy Tinker, Your Honor. The court in Tinker and Healy said that when a university reasonably believes that expressive activity will result in substantial harm, the university is allowed to take reasonable steps to limit that expressive activity. So here, the
Do you
question.
remember the facts of Healy v. James? And that was the SDS and the allegedly rioting and so forth. Is
That's
that
right.
not correct?
The problem.
But even there, the court said we need development of the factual record to look at actual intent. Is that not correct?
That isn't true. The court remanded the case and said that if the university could provide the district court with evidence, any evidence, that it had a reasonable belief that substantial disruption would occur at some point in the future, the university would be able to prevent the students from meeting on campus, prevent them from even using bulletin boards around campus. We have a threat of substantial disruption in this case.
Do you concede Hazelwood really doesn't apply? You spend a lot of time. Do you concede that now?
No, I think the question of whether Hazelwood applies to this case is a close one. There are two reasonable ways of reading the case.
How would you write around Healy that says First Amendment protections do not apply with less force on college campuses than the public at large?
I think that's right, but you could read
So
Hazelwood.
you can't reconcile Hazelwood with that, can you?
Well, I think you could read Hazelwood to say that it's about the reasonable right of a university to limit expressive activity when students hold that speech out to be approved or endorsed by the university, as they did in this case. After all this.
But that, again, I was going to ask you about that, because to me, that's another somewhat red herring, because, again, that isn't your problem. I mean, whether or not the university is endorsing it or isn't endorsing it isn't why it's upsetting you. It isn't why you want to close it down. It's because of what's in it and the fact that you believe it to be dangerous in some fashion. And again, you'd be just as upset if it was on a different website that said clearly on top of it, this is not the university. That's not what's bothering you.
I think that's right, Justice Berzon. So if the court rules under Hazelwood today, it would only help us in this very specific case where the paper is posted on the university's website.
But the doctrine ought to have something to do with the problem, and it does nothing. This question of attribution is just beside the point in this case, isn't it?
I think there is another problem of what would happen. Of course, we have no indication that the petitioners have some intent to post this paper on, some other hacking website or somewhere else. And I think that would pose.
What I'm saying is you've lit onto this attribution problem because it happens to be in Hazelwood, but it has nothing to do with the interests that are at stake in this case, with why you don't like it, with why they want to do it, or anything else.
I think that's right. Of course, Hazelwood would help us on these specific facts, but I think in general, Healy would allow this court to rule for the university if it believes that the university had a reasonable belief that substantial disruption would occur.
Doesn't it matter at all that the disruption, if it occurred, is ultimately traceable to the university's own dereliction, i.e. that the system is no good? And the fact that they happen to have pointed out that the system is no good isn't really what's creating the problem. It's that the system's no good.
I think it actually would create a problem. Of course, there are federal statutes that require the university to protect student medical information, protect student credit card information.
And apparently they're not doing it. And the fact that somebody's pointing it out isn't what's creating the problem. The fact is they're not doing it.
Well, we can imagine it would be an even larger problem if at this point, now that the university is aware of the problem, if it simply allowed this detailed explanation to be posted online without being able to tell its students, we're taking care of the problem.
At the end of the day, what the paper says is the truth. Is that not so?
There's
no challenge to it not being the truth.
It is true that there are...
They're speaking the truth about the university. That's correct?
It is true that there are...
And they're not advocating hacking in. Isn't that correct?
That's right.
So there's no advocacy of bad activity. That's correct. So why can't they speak the truth about the university?
The problem is that by including we have no objection to many parts of the paper that simply describe the problem.
But the problems in the security system are the truth. Is that not correct? That part of the paper is the truth.
Well, the IT department right now is verifying whether those problems.
But in this case, you've never contested it, that it's the truth.
That's correct, Your Honor.
So you took down a truthful paper of a student. Is that correct?
That's correct. And that's just as we haven't contested that, the petitioners haven't contested.
So we can't speak the truth about the university, even though we don't advocate anything wrong. Is that your position?
That isn't true, Your Honor.
All right.
What we
is your
say is
position?
that when the university created a limited public forum with reasonable rules, it is allowed to say to the students, we're going to give you access to the internet, but you can't use the university's own internet access to distribute hacking instructions that would be dangerous to the students. Your Honors, the parties agree that public universities should limit speech
What
only.
evidence do you have in the record that there is any danger to the university? We have just the paper. There's not any testimony. There's no other evidence, is there?
The statement of joint stipulated facts says that the explanation would allow hackers to successfully hack through Ames State system. And as the petitioners concede in their complaint, it would allow hackers to shut down all campus security. Your Honors, the parties agree that universities should limit speech only in very narrow circumstances. But here, where the petitioners violated limited public forum rules and threatened to cause substantial disruption, this case presents those circumstances. Thank you, Your Honors.
Thank you. Mr. Ward.
Thank you, Mr. Chief Justice, and may it please the Court. Characterizing the petitioner as insubordinate is not a serious enough charge to ever threaten his constitutional liberty. Every circuit to address the question, in fact, has held that insubordination is not sufficiently stigmatizing.
How is that case issue before us?
Your Honor, I believe that issue is fairly included under this Court's Rule 14.1a. The certified question asks whether the petitioner has a 14th Amendment interest in preventing the placement of stigmatizing material.
Right, which is
in his
essentially,
file.
as I understand it, there's a four-part test, and the question assumes the answer to three of them and leaves the fourth for us to decide. And to start backtracking now as to the stigma seems to completely compromise our rules in terms of questions presented and our authority to grant or not grant certiorari based on the question presented.
No, Your Honor, we're not saying that. The four-part test is a test that certain circuits have identified. It's certainly not one that all circuits have applied. This Court has said that not all stigmatizing information counts as information that would deprive somebody of his constitutional liberty. 9 circuits have said that information must be, quote, sufficiently stigmatizing to implicate a person's liberty.
I thought in the
end
district
quote.
court you only litigated the fourth part, public disclosure, and did not contest the stigmatization issue. Is that not correct?
That's correct, Your Honor.
All right, so how can you raise it for the first time on appeal?
Well, Your Honor, I don't think that should preclude this Court's consideration of the issue today. At the time the petitioner filed his complaint, as now, this Court's standards governing how to make out a liberty interest claim were not in doubt. Your Honors, keep in mind that the
But isn't there, if you had raised the issue below, the other side might have put different information in the record, may have, for example, put experts on as to whether or not this was stigmatizing.
Exactly, Your Honor, and I think it should have done so. In
But
fact,
you didn't raise the question. Why would they have done so?
Well, Your Honor, until the district court wrote its opinion granting summary judgment, there wasn't a four-part test to apply. The district court just decided to apply the Ciolino test, but that isn't a test.
Who moved for summary judgment?
We did, Your Honor.
All right, and what was your basis for summary judgment?
Our initial basis for summary judgment was that was the public disclosure prong, Your Honor.
Not initial,
No.
sole basis.
That's right, Your
All
Honor.
right, so that's the
right.
sole basis in the district court, and you cannot raise a new issue for appeal. Isn't that well established?
I don't think so,
That the
Your
district court has never had an opportunity to rule upon. Isn't that clear under the law?
I don't think so, Your Honor. Under this Court's Rule 14.1a and also under this Court's Rule 15.2, this waiver is discretionary, Your Honor.
Let me tell you, we have enough to decide about what we have to decide. We don't decide what we don't have to decide.
I understand, Your Honor. And keep in mind,
As
this
we
is...
often say, you may want to move on to your next point.
Your Honors, in any event, the petitioner should not prevail today for a second reason, and that is that he is simply not entitled to a hearing at this early time. Even if his liberty is on the line, if it's at stake, The 14th Amendment, what the 14th Amendment requires is a meaningful chance to clear your name. And the petitioner would have that chance, so long as he gets a hearing at the point of public disclosure, when his file
How will he find out?
I'm sorry, Your Honor?
I mean, how will he know?
Your Honor, I don't think this court should be worried about enforceability.
I'm worried about him. He doesn't know. I mean, how does he know that that the newspaper is going to publish this tomorrow? And moreover, we now agree that this information in here says this man is the bottom. He is the worst. He is beyond belief. We have never seen anyone in our entire lives as horrible a teacher as him, okay? So we're operating on an assumption that it is something like that. Given that assumption, he doesn't want that to appear in the minds of other employers until he has a chance to talk about it. Hence my question. If, in fact, the university is going to show it to other employers, how does he know when to act?
Well, Your Honor, due process requires both notice and an opportunity to respond.
So now you say what? Now you're saying that the due process clause requires them to give him notice prior to any effort to show an outside person. Is that what you're saying?
Yes, Your Honor. Now, it
Okay,
depends.
so he might accept that. He says, I thought this was a good time because this is before he showed it to every outside person. And you're saying I'm right about that. It's just that we should wait till it's closer.
Well, you're right, Your Honor. Right, Your Honor. Exactly. I think
So that's what this argument is about. The argument is between your saying, we agree we should show it to you before we show it to any outside person. And you agree that we should do that. You want it immediately, and we want a little bit of time until it's imminent. Is that the argument?
Well, Your Honor, we propose two separate rules. Now, I'm confident that if the petitioner gets a hearing at initial release of his file to a single
The
prospective
brief
employer,
is vague on that. Initial release of the file, is that before it's released or after it's released?
it's just after release, Your Honor. That's
right,
the
so-
standard.
Well,
That's
I-
the
After
first.
release, then all the
something-
damage has been done.
So in other words, after the damage is done and after it's all over, I mean, again, the degree of stigma here somewhat colors the question. But let's suppose what was in there was he murdered his wife and he, drowned his children. And that gets released at some point to a prospective employer, and then the next thing you know, it's in the newspaper and so on, and then you're going to have the hearing?
Well, Your Honor, it depends on what this court believes its conception of liberty interest is and has been over the past 50 or 60 years. And Your Honor, I think that the court's definition or conception of liberty is in the ability of a person to pursue his profession. Now, I don't think when a single prospective employer learns of information in the petitioner's file that his ability to pursue a profession is going to be
The
deprived.
rumor mills are pretty good. I mean, among university employers, for example. If something gets out to one person, you can bet it's going to get further than that. And besides, it doesn't matter. Somebody already knows this. Maybe that's the one job he wants, and now you're going to take 3 months to deal with him while he's, meanwhile, being denied the job?
Well, Your Honor, I don't deny that there are certain circumstances, probably narrow circumstances, as the hypothetical you posit suggests, in which losing one job would be a deprivation of liberty.
I asked him this, and you both seem to be avoiding the obvious solution, which is to do it at the point at which you're about to release the information to somebody. Why not?
Your Honor, I think that's an excellent alternative rule, and a species of that rule is the one we propose as a second rule in our brief.
But you don't like it. Your brief you say it briefly, and you say, oh, but it's not really what we want.
Your Honor, we're happy with either of those rules. I think that it's perfectly reasonable that this court could find that at some point before Ames State releases the petitioner's file, it has to grant him notice and a hearing. In that case, the contents of the...
Before they release it.
That's right, before they release the file.
Do they intend to release the file at some point to somebody?
In the present case?
Your client, yeah.
It depends, Your Honor. It depends on whether the petitioner's file is ever requested. And indeed, the petitioner...
Well, imagine it's requested. Will they release it?
They will release it only after the petition. If this court adopts that second proposed rule, they will only release it after the petition.
Okay, but you're saying that their custom is that if somebody asks for it, they release it. Is that the practice in this university?
Well, it's not clear from the record whether that is the practice.
Well,
but I think,
what do you think?
Oh, I don't think it's relevant here, Your Honor, because
I might be relevant. I mean, if the practice is that they do release it when somebody asks for it, and you agree that there should be a hearing before somebody asks for it, then I might say, well, why not now? Memories are fresh. people are bound to ask for it. I mean, it's most unlikely they won't. So if that's the custom, let's do it.
Well,
We'll get it over with.
I'm sorry, Your Honor, again, the record isn't clear on that
I
point.
know,
But
so
even
then
assuming,
maybe they're never going to release it. Maybe the custom here is they take this record, they share it among themselves, and they bury it in a vault.
That's right.
It's in the Nevada salt mines. It is there with the atomic weapons. And there we are. Nobody's ever going to get to it, ever. In which case, maybe there is no need for a hearing, and we don't know which is which.
That's
so we have now two things we better find out.
Well, Your Honor, I think even if it is the university's custom to release a file upon request, I think Your Honor's question perfectly points up the principle this court identified as being extremely important in Matthews. In Matthews, what this court said is that crafting procedural safeguards is a difficult task, and it doesn't always yield perfect answers. Instead, what the court is to do, and what the court in Matthews said that it does, is craft rules that accommodate competing concerns, that balance the interests of individuals and additional protection against the burdens that those additional
Speaking
protections.
of those burdens, why can't your client simply adopt a rule, we won't release it, and that would remove all burden? Why wouldn't that solve the matter?
I think the problem, Your Honor, is that in cases where employees are wanting to apply to prospective employers who do request files, then they would face a competitive disadvantage in doing so. But, Your Honors, there's a reason that the first, second...
So here you're just saying we want to delay when we do it, not that we don't want to do it at all. Is that your position?
Your Honor, absolutely. If the petitioner's liberty is on the line here, then there is no dispute between the parties about whether he gets a hearing. The question is when it should happen. And the reason that's relevant, Your Honor, is because of Matthews. Because under the petitioner's rule, numerous additional hearings would result than under our rule, even a before-release type rule. Your Honor, the petitioner's rule in particular would impose extraordinary burdens on not just Ames State and not just public universities, but on all government employers across the country.
Well, but you have a very odd rule, which is that you will release it to public entities, not to private entities, which certainly suggests that your interest in releasing it is not a very strong one. I mean, if you're dealing with university systems, why should it matter whether it's Harvard or the University of Michigan that asks for it?
Your Honor, I'm not sure. I think probably partly that rule is in place if public agencies want to get the petitioner's file for some reason. But I do think that
it certainly suggests that from your point of view, there's not a very strong reason. And the reason you gave, for example, can't be the reason, because Harvard's going to be just as interested in getting it as the University of Michigan. He's going to be just as prejudiced by your not releasing it. And yet you say you're not going to release it to Harvard, and you are going to release it to maybe to the University of Michigan. So this rule must be about something else.
Well, Your Honor, even if I take your point, and let's just assume that let's read that regulation as generously as we can to the petitioner's position. I think even in that case, there is a reason that the First, Second, Third, Fourth, and Seventh Circuits have each rejected the petitioner's rule in turn. The rule would impose numerous additional hearings, would require numerous additional hearings for government employees across the country. It would grant hundreds of thousands of at-will government employees a brand new constitutional right.
Why would it? Because as my colleague says, all that the university or the employing agency would have to do is tell the people who give references and information, our private file is private. You're giving it to us. You're not giving it to other people. Now, why can't they say that? And if the other person wants to find something out, he can find it out for himself. That way we keep the information private. We only use it for the purposes for which it is intended, namely this person at this school, and nobody's hurt.
Your Honor,
why is that a big problem?
Well, Your Honor, the first point I raised, I think, is a relevant one, which is that employees in those circumstances might face a competitive disadvantage when applying for jobs.
But the only for public jobs, not for private jobs.
That's right, Your Honor. The second point, well,
it's not right. It doesn't make any sense.
Right. Well, Your Honor, Your Honor, the second point is that even if that is a rule that Ames State should adopt, and I think that's a great suggestion and a rule that Ames State should take under advisement, that still doesn't mean that the Constitution requires it. It still doesn't mean it should become a constitutional right. Your Honor, this court has long expressed a concern, for example, in Connick and in Garcetti, about constitutionalizing the
But
employee
ultimately,
grievance.
as Justice, the Chief Justice pointed out in the earlier argument, nobody is really contesting the notion, you're not, that at some point along this continuum, you do have to give a notice in a hearing, right?
That's true if the petitioner's file is ever requested.
Well, that's right, but that, I mean, there are all kinds of problems with that right there, like my hypothetical about what if somebody's walking around with the information in their head and not on a piece of paper, but you don't seem bothered by that. You're just trying to delay you're not questioning the basic structure, you're just trying to delay the time at which the hearing has to be given.
Right, Your Honor, not until it's necessary. What the petitioner's rule would do is require subsidization of, in many cases, unnecessary hearings. There will be premature hearings, and in many cases, they will be unnecessary. And Your Honors, the petitioner's rule imposes
How is that going to
these-
be an adequate remedy when it's 10 years later, as the Chief Justice mentioned, and memories fade? Nobody can remember what occurred.
Well, Your Honor,
Why is that a meaningless remedy at a hearing at that point?
well, Your Honor, if Dean Andrews is not around Ames State at that point, then the university won't have witnesses to support its case, and the
No, but the
petitioner's
memo
hearing
will
would-
still be there.
That's right, but the memo uncontested, the petitioner will have the opportunity at that point to contest the memo in his file. And
What if you just had a rule that said, if we put something negative in your file, we will tell you, and you can put something, you can contest, you can put a contest in like credit agencies do. Why would that be any skin off your back? Universities back.
Your Honor, that sounds like a reasonable rule. That isn't, of course, what the petitioners demanded. On page 7 of their joint appendix, they demand a full-blown name-clearing hearing, complete
But why
with
wouldn't you be
production.
better off defending a reasonable rule like that one rather than an unreasonable rule like the one you have?
Well, I think that's a rule that the university could take under advisement, Your Honor. Again, there is a difference, though, between having a good rule and whether the Constitution requires that rule.
What is the rule? What is it? I'm still uncertain. As far as I could tell from the briefs, there's a case called Owen in which a police officer or chief was in fact fired, and there was some other information, and there's a footnote, perhaps written by a law clerk in the case. I don't know. And in that footnote refers to a case called Roth, which is a well-known case in this faculty particularly. But and Roth was involved. I thought it was a probationary teacher.
That's exactly right, Your Honor.
Now, what is this? What is this right then in those cases? I actually am quite uncertain as to its scope and what the heart of it is and why it's there and what is it.
Well, the liberty interest, generally speaking, is in the right to pursue a profession. Now, more specifically,
right to pursue a profession, so you can't tell somebody you, for no reason at all, are not going to be a Mississippi River pilot. All right, I got that one. This seems pretty far removed.
Right, Your Honor. I think the court has never precisely defined the boundaries of what counts as a liberty interest or what doesn't, but it has given
What do
some,
you think about that?
Well, it's given some clear guideposts. What I definitely think is that the petitioner's conception of Roth is, with all respect to the petitioner, wrong on the facts of Roth itself. What Roth said is that being made less attractive to a future employer, though it might diminish job prospects, isn't enough to even implicate a liberty interest, let alone deprive a person of it. Now, the court has given certain guideposts for...
What about Owen?
Your Honor,
in the footnote, what has that to do with anything?
Your Honor, when the petitioner cites Owen in his opening brief, he misquotes the parenthetical, a parenthetical including Roth. Your Honor, I think that's at page 26 of his opening brief, but I'm not positive. Your Honor, the important point is that this court has laid down very specific cases in which liberty is deprived. For example, if an aspiring lawyer is denied entry to the bar, he has a liberty interest at stake. If an ex-government employee is foreclosed from all federal job opportunities, he has a liberty interest at stake. There isn't a liberty interest at stake here, and even if there is, the petitioner doesn't need a hearing at this early date. Thank you.
Thank you. 3 minutes.
Mr. Chief Justice, and may it please the court, we'd like to respond to 2 points. First, Respondent's characterization of Tinker and Healy mischaracterizes those cases and would eviscerate the standard those cases stand for, because in both cases, the educational administrators stated that they reasonably believed there would be a material and substantial disruption, and in both cases, this court, imposing First Amendment requirements, rejected that subjective belief of the university and required instead a court in an objective sense to determine the truth or lack of truth of that assertion.
How can we do that in this case without the document?
Your Honor, that's precisely why the grant of summary judgment is inappropriate as regards the guidelines, as Your Honor's asked.
The district judge had the document, didn't he? But we don't have it. Did the district judge have the document?
It's indicated from the record that the district judge probably did, though it's not sure, and she may have based it on the complaint and the abstract as well.
She couldn't base it on the complaint, could she?
It would have been a broad reading of the complaint, I agree
But
with you.
the complaint isn't what we have before us at this time. We're on summary judgment. What we have is the facts that were actually stipulated to. Isn't the complaint irrelevant at this point?
We would agree, Your Honor, and certainly the characterization of the complaint in Respondent's
Well,
brief.
just irrelevant. That characterization or anything else, it's not the facts. The facts are the facts.
And that's correct, Your Honor. And the district court on remand, this case should be remanded because the standard the district court applied, the standard from Hazelwood, is inapposite in this case and doesn't present nearly the kind of speech protection required in universities under cases like Tinker and Healy and Papish, applying, of course, the Tinker standard in the university itself.
The district court judge says that, as they pointed out, that the plaintiffs summarized the results of the research, including a detailed explanation of how hackers could attack the system successfully. All right, now did you tell the district judge, that's not actually right? It doesn't give detailed explanations, at least nothing practical. It doesn't really enable people to break in. Did you ever say that? No.
It's unclear, but probably not, Your Honor, what we said
No,
to the
because you stipulated that it did. We don't have a complaint. We have a stipulated set of facts. Is that not correct?
That's correct,
And
Your
the
Honor.
stipulated set of facts are that you gave a detailed explanation that a hacker could use to successfully hack in. Is that not correct? That's
Yes.
the stipulation.
That's correct,
So
Your Honor.
why doesn't that present a substantial likelihood of harm to the university?
Your Honor,
And more particularly to the students whose private information the hacker wants.
Your Honor, the threat to the university was, before Petitioner's paper, and remains the underlying security vulnerabilities. And Petitioner's presentation to the university of the solutions is not the cause of the substantial material threat.
No, the cause of the substantial problem is what they say is there happen to be a few people that even if they could have broken in, don't know how. And so luckily for all concerned who are interested in breaking in, your client's paper explains just how to do it. So therefore, they're much more likely to break in. That's the natural inference.
Your Honor, my time has expired.
Well, go ahead. You can answer the question if it was a question, which it was meant to be.
I'll presume a question mark on the end, Your Honor.
Yes.
In essence here, the threat to the university, which it had failed to fix, predated Petitioner's paper, and Petitioner's paper, which was a crucial contribution to the marketplace of ideas, allowing university to fix that problem, should not have been suppressed.
Let me ask you this question. I've been in the Supreme Court a couple of times. I've figured out how to bypass security, and I've just posted my paper on the Supreme Court's website. Can Justice Breyer take it down?
No, Your Honor. Chief Justice Breyer should talk to the U.S. Marshals and tell them to close the security vulnerabilities.
So he couldn't take it down off his own website?
Because I don't know how to work it very well.
Your Honors, in this case, the university
So
violated...
I could do that. I could post it up there, and he couldn't take it down.
On Chief Justice Breyer's personal...
No, on the Supreme Court website, the judiciary, federal judiciary. We have a website. Everybody can post stuff on it.
Your Honor, it's unclear, of course, whether that would be a designated public forum. If it was a non-public forum, a different standard would apply.
Thank you.
Thank you very much.
Thank you very much. Thank you all.
All rise.
Well, I mean, we thought it was pretty tough to make this decision, I'll tell you. It was, I mean, after all, first of all, this is the nightmare case of all time. It's sort of, Creature from the Black Lagoon, Part 7. I mean, and I mean, Brady, when he was the substitute, then became the greatest quarterback of all time, and I have no such prospect in the offing. So there we are. But it's very hard, and you all did a very good job. And people who don't understand what a nightmare this case is, which we now do, perhaps don't realize what a good job you did, and you did. And we had a very hard time saying who was better, but I'll put you out of your uncertainty on this. On the brief, we chose the respondents. We thought they had a slightly better brief. On the oral argument, we chose Mr. Zimmer, which was on the petitioner's side. And the best overall, I mean, this is just absolute. I mean, it could be either side, I promise you, because they were really excellent, all four. And though I know we have to choose somebody. So we chose the petitioner, and there we are. I'd like you also to give a hand to the respondents because they did a very good job and it could well be more. And my colleagues may.
Well, I certainly concur with the Justice. I do have a couple of comments. First, modern-day oral arguments really are conversations with the court. Lawyers do not stand up and give speeches, and each of you did a very good job of having a dialogue with the court. Good eye contact, you answered the questions the best you could, if you could understand the question. You did a great job in that regard. Judges up here are just the referees. The most important persons in the justice system are the advocates. And I want to congratulate each of you for not only choosing to be a lawyer, but to spending all the time that you have done to enhance your advocacy skills through this competition. It's a tremendous amount of time, and I congratulate you on doing that. I'm absolutely convinced each of the advocates here will one day be a very important advocate for someone in our system of justice and will make a difference through your advocacy skills that you have enhanced through this process. So I congratulate each of you.
I would like to second what Judge Hull said. In general, I thought that all of you were extremely well prepared, that you were responsive as best you could be. As Judge Hull suggested, sometimes we may have been a little obtuse or obscure. And you were able to deal with sort of out-of-the-box questions without showing discomfort or dismay. In style, you were exceptionally good. All of you were did not have redundant ways of answering. You were spoken clear sentences. You were not discomforted by being asked many questions. And in general, I thought the oral work was terrific. There, in terms of the briefs and the arguments, you obviously had to make certain strategic decisions, and some of them dug you into a few little holes. I'm sure you had reasons for making them, and I'd be interested in hearing them afterwards. The case, as our Chief Justice suggested, was something of a black lagoon, and you did the best with a very hard situation. So thank you very much.
And thank you all.